Today, we're diving into a high-stakes legal battle in the world of real estate tech. But this isn't just about property listings. This fight has gone all the way to the Supreme Court, and honestly, it could completely rewrite the rules of competition for the entire digital world.
So let me start with a question that's at the very heart of this whole thing. Can you actually be a monopoly if your customers aren't technically forced to do business with you? I mean, think about that for a second. The answer could totally change how we think about powerful companies online. Keep that question in your back pocket, because we're going to come back to it. So how in the world does a business dispute between two real estate companies blow up into a case for the Supreme Court? Well, it all started when CoStar Group, a giant in the industry, decided to go big. They formally asked the highest court in the US to step into their ongoing antitrust fight with their rival, CREXI. Now, you might see the names and think this is just some niche industry drama, but no, the outcome of this case could send massive shockwaves through the whole digital economy. What gets decided here could seriously change how all kinds of online platforms have to operate. This is a big deal. Okay, so to really get this showdown, you need to know who's in the ring. On one side, you have the reigning champ, the established leader. And on the other, you've got the scrappy challenger looking to shake things up. Let's meet the players. So in this corner, we have CoStar Group. They are the undisputed titan, the Goliath of real estate data. And in the other corner is CREXI, the upstart rival, kind of playing the role of David here. It's a classic setup, right? And this whole legal battle started with a pretty serious accusation. It all kicked off back in 2020. CoStar sued CRXI for copyright infringement, saying they stole thousands of their property photos. But here's the twist. CRXI didn't just defend themselves, they countersued, claiming CoStar was an illegal monopoly. Now, a lower court threw that out at first, but then, in a huge turn of events, an appeals court brought it back to life. And that single decision is what brings us to today, with CoStar knocking on the Supreme Court's door. All right, let's get into the real legal nitty-gritty, because this is where it gets fascinating. The big question isn't just, is CoStar a monopoly? It's something much deeper. It's about how we even define a monopoly in a world of digital platforms and, these so-called non-exclusive deals. At the core of CRX's whole case is a law that's been on the books for way over 100 years, the Sherman Act. This is basically the foundation of America's antitrust laws, and it was designed specifically to stop companies from getting so powerful that they kill off all their competition. So here's CoStar's main defense. And you gotta admit, on the surface, it sounds pretty reasonable. They're basically saying, hey, how can we be a monopoly when our contracts are non-exclusive? Brokers can use anyone else they want. From their point of view, the plain text of the contract should be the end of the discussion. But the Ninth Circuit Court of Appeals didn't buy it. They essentially said, whoa, hold on, let's look past the words on the paper and see what's actually happening in the market. And they decided that, yeah, a company's behavior can absolutely be monopolistic, even if their contracts claim to be non-exclusive. That one ruling just blew the whole case wide open. So, with the stakes this high, you can bet both sides have some pretty strong arguments. Let's break down exactly what they're telling the Supreme Court. Okay, so CoStar is sounding the alarm. They're arguing this appeals court ruling is a really dangerous precedent that will discourage innovation. Why? Because it could force successful companies to just hand over their hard-earned data to competitors. CREXI, on the other hand, is saying actions speak louder than words, or contracts. They're arguing that CoStar is flexing its market power to crush rivals, and that this whole Supreme Court thing is just a fancy delay tactic. Now, I know what you might be thinking. Okay, this is interesting, but I'm not in commercial real estate. Why should I care? Well, here's why. The result of this case could have a direct impact on so many of the digital services you use every single day, from how you shop online to the social media apps on your phone. The key takeaway is this. This case is putting our old laws to the test in a totally new digital world. It's forcing us to figure out how century-old antitrust rules apply to modern data-driven companies. Whatever the court decides here is going to set a huge precedent for what's considered fair game online. And trust me, it's not just real estate folks with their eyes on this. We're talking major tech companies, software platforms, and even government regulators. They are all watching this case like a hawk, because the outcome could totally change the way they do business. This case really highlights a fundamental tension in our economy. On one hand, you want to reward companies for innovating and investing, but on the other hand, you have to make sure that the biggest players don't use their power to just shut down any new competition. It is a really delicate balancing act, and this case could tip the scales one way or the other. So, what's the next step? Where does this landmark case go from here? Well, right now, its entire future is in the hands of the 9 justices of the Supreme Court. It really all comes down to their next decision. Basically, there are 2 ways this can go. Path number 1, the Supreme Court agrees to hear the case. If that happens, we're looking at a full-blown hearing, and we probably wouldn't get a final decision for a year or 2. Path number 2, the court says, nope, not interested. If they deny the petition, the appeals court ruling stands, and the case heads right back to the lower courts for a massive antitrust trial. And that leaves us with this huge, central question for our modern world. Where exactly is the line between being a successful market leader and being a market bully? What's the real difference between a company that won the game fair and square and one that's rigging the rules so no one else can even play? The answer might just be decided by this very case.